Good morning, all. This ex parte urgent application hearing is in the matter of CFI 008-2025 before His Excellency Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Amareller Legal Consultants. Lead counsel is Mr. Christopher Gunson. Thank you, Your Honor.
Yes, Mr. Gunson.
Your Honor, good morning. So I'm pleased to proceed in any way you instruct. I believe you have most recently our revised model order. Of course, I have our application and the evidence. We have our skeleton argument. I'm pleased to go through it on your instructions.
Yes, well, a couple of technical points first of all. The affidavit, as I read it, doesn't specifically verify the truth of the facts and matters set out in the application. Unless I've missed it, you say you rely on the application, but there's nowhere saying it's all true. And one of the fundamental things about an affidavit, and the reason for having it for any sort of an injunction, is that it needs to say that all the facts and matters that are relied on are true. So you may need to swear a short corrective or additional affidavit, and I may, unless you can point to something to me which shows I've missed it, I'll be requiring you to undertake to swear a further affidavit just saying all those matters are true.
So, Your Honor, if I refer to my affidavit that I have submitted, in point 3, I have said that the facts of the matters set out in this affidavit are either within my knowledge or are based on information provided to me by the claimant, and I believe it is true. There is an omission of the nature you're referring to in the defendant's application.
Bear with me a moment. I'm afraid I have a slight problem this morning, Mr. Gunson. I've only got one screen, whereas ordinarily I have 3, and therefore I'm fiddling around, moving between seeing pictures of you and the various documents. But give me a moment.
Very sympathetic to this position.
So the page in the bundle you're referring to is of your affidavit?
So I believe I'm referring, but it's item, it's section A2 of the bundle. So I'm referring to section A of the bundle. And in that, after the index, we have the skeleton arguments, and then we have our claimant's application for a freezing injunction. So at the conclusion of that, there's a statement of truth that I've signed. The content of the above evidence in support of this application is true to the best of my knowledge and belief. And then furthermore, in the affidavit submitted in paragraph 3, I have made a similar statement. The only incorrect swearing statement of truth I'm aware of was made by the defendant in his application that was dated on the 13th of June.
Let's leave that to one side for the moment.
But if I would refer once again to my...
yeah, I'm just looking at it. It's, yeah. I suppose it's a highly technical point, really, but your paragraph 3 says facts and matters are within your knowledge or based on information. Where they're not within your knowledge, I believe them to be true. So you don't actually say that the facts that are within your knowledge are true.
Your Honor, I'm pleased to swear that the facts of the realm of my knowledge are true. And if that's an omission, then it's one that was made inadvertently.
Well, I appreciate that, but it's nonetheless the sort of thing that needs to be put right. I mean, ordinarily, as I'm sure you're aware, you would ordinarily say, where the facts are within my knowledge, I confirm they're true, and where they're not within my knowledge, I believe them to be true, or best of my knowledge, information and belief, and so on. So you're missing a sentence there, aren't you? But anyway, if you can undertake to swear a further short affidavit to that effect, that will cure that problem.
I'll remedy that in writing promptly upon the conclusion.
Well, what we'll do if I make the order is we'll have an undertaking in the order to swear an affidavit to that effect and serve it with the order if I make it. So that'll be a part of the order, and then you can do that speedily. Now, I haven't had a chance to look at what I think you've just sent to the court, which is based on the model order, but we'll come to that again in due course. What I'd like you to do is just take me through the basis of the application. I remember some of the details of this, and I spent an hour or two last night looking at back through the documents, but can you just take me through the basis of your application, please?
Certainly, Your Honor. The background to this is that the claimant signed a contract with Defendant 2 to invest money with him, by which he held himself out as a qualified businessman with many projects and opportunities. He failed to perform or to return the investment pursuant to a contract, despite a one-year grace period in that contract. Given that failure, the claimant filed with DIFC courts for breach of contract. The court issued a default judgment and thereafter an order noting, if I was to summarize and restate the court's order, the defendant's defense was so poor that to appeal it would require the judgment amount to first be paid to the court. We believe no amounts have been paid to the court, but the defendant has filed 2 successive applications to ask the court to vary that order.
What's happened to the position of the first defendant? I gave permission to the first defendant to file a defense. Did he file a defense?
The first defendant did file a defense, and we have filed a response, and we look forward to going before the court with regards to that matter.
Right, but I got the impression from the evidence that the first defendant had been cooperating with you to identify assets of the second defendant. Am I wrong?
That is not, we believe, an accurate representation of the situation at all.
Right. I thought I'd read somewhere in one of your exhibits, Mr. Gunson, that the first defendant had been pointing out to you a couple of assets of the second defendant. Am I wrong? Have I misread that?
So if we would go through the exhibits, there have been times in the past by which the defendant 1, who of course was originally retained by the claimant to advise him on relocation to Dubai, after introducing and reassuring the claimant about the quality of the defendant 2 as a secure place to invest his money, after that, we then had a situation where the defendant 1 was giving vague information about information, some of which I think has been confirmed, but it is, I would not describe it as helpful in our search for assets that must be executed against.
All I need to know for present purposes is that there are live issues between you and the first defendant that are currently being pursued in the litigation, with pleadings having effectively closed, and we're coming up for directions on that in due course, no doubt. All right. Okay, well, I've understood all that. And you can take it, Mr. Gunson, that I've not only read the order that I made on the application to set aside the default judgment, but I've looked through the material, including your affidavit and the two witness statements that came, one from lawyers and I think then one from Mr. Rashid himself. What I need you to do, essentially, I think, is to show me why I should conclude today that what has been said so far about existing assets is false. That's the essence of the reason why you say an injunction is necessary. But let me just say this to you. The position currently is that you have a judgment in your favor and 28 days have passed and you're entitled to execute it. So that I don't need a lot of persuading about, well, I need no persuading about good arguable case and so on and so forth. That you've got a judgment in your favor and you don't need to fortify any undertaking that you give in relation to damages because you're entitled to execute in any event. It's just a question of finding some assets to execute on. So, but take me to the falsity of what's been said. That's really the key thing I need to look at.
Your Honor, we are indeed ready to execute, but of course, the claimant does not want to spend further fees on execution that end up resulting with, of course, a process that's, yes, in a result. What we have with defendant 2 is a repeated pattern of behavior that is misrepresenting the situation. From the beginning, he said, I have revenues of $25 million a year. This investment of $1 million is nothing to me. And yet then we just see repeated misstatements or we see repeated evidence and statements given that are contradictory and in some cases inaccurate what we know, even from public records. And as, of course, as Your Honor knows very well, it's not easy for a claimant to learn about the assets of a defendant against who he has a judgment. But even from public records, we can see that the defendant 2 has company registrations in other countries that he has not talked about. He may have been shifting things into his family or his wife's name, for example, to frustrate enforcement. And what we see in the first application that was given on the 13th of June that was signed by his counsel, we knew instantly this was incomplete. And as a courtesy to counsel, we informed them. We know this is incomplete. We'll be filing a response accordingly. We recommend you get your client to redo this and correct it, because this is not an application you have been required to submit. It's one that you have voluntarily submitted, and we know it's not true. And the second application that was submitted on the 18th of June was much more substantial, showing that the first application was incomplete, and yet still we know, as set out in our order and in the exhibits set out as set out in our application and as set out in the exhibits, we know there are still many omissions that are there. And this also, I think, is a very important point. The defendant 2 has had a business in Dubai that has been operating for, I believe, 7 years. After the order was issued, that website went down. As of this morning, that website is still unavailable. So this broadcasts to the world that the defendant 2 is seeking to flee and frustrate the judgment against him and frustrate the execution proceedings. So, of course, a freezing order that would be given is not something we would have forever. It's something we would obtain and then proceed to execution. We understand that an execution order, or that a freezing order, and also an order to disclose assets is it's very burdensome on the person who is the subject of it, but it is not something we seek to have there and then leave it. It will be part of our execution proceedings. And so if Your Honor was to issue it, it would be followed promptly by execution proceedings. That is a summary
Do you
of.
do you expect to find assets in the DIFC and in Dubai or abroad? I mean, obviously there's shareholdings in companies that are incorporated and registered elsewhere. Tell me what you hope to find.
We would expect, it's very likely that the defendant too has assets that he may have transferred in Dubai, that he may have transferred to his family or other members of his network recently, which is why we request that information on any such disposals dating back to the 1st of January 2024 be disclosed as well.
Is there any particular reason for picking the 1st of January 2024?
That is at around the date that the investment, I would say, liquidation notice was issued, at which time the defendant had 1 year to repay back the investment in full.
Got you. All right. Well, can you take me to a bit of the detail about the missing assets, those that you say you know exist that haven't been disclosed, by taking me to the relevant exhibits in question or whatever?
Certainly, Your Honor. So I will refer to the exhibits. So I will skip exhibits 1, 2, and 3, which are related to the behavior of the defendant, which I think is also important, and which I've referred to now regarding the taking down to the website. But I can speak about those additionally. In exhibits 6 and 7, we have the agreements that have been signed between defendant 2, witnessed by defendant 1, and the claimant. Here, what do we have? We have a representation that defendant 2, if I quote directly, is currently running various businesses in the UAE, operating the logistics, F&B, tourism, restaurant, hospitality, manufacturing industry. So there is already a statement, a representation that defendant 2 has multiple businesses in the UAE. I believe that the defendant's application made on the 13th and 18th of June did not make sufficient disclosures regarding these. These may, of course, have been complete fabrications and misrepresentations, or there could have been important development since these contracts were signed.
Yeah.
So if I then go on to, Exhibit 8, 9 and 10 refer to, and also 11 regard to, I would just say, the conduct of the defendant 2 in making various representations. But Exhibit 12 is, I think, also material to this point. If I want to take his money, and I'm quoting here directly, this is the defendant 2. If I want to take his money, and this is a very small amount, $1.2 million, it's nothing. So we have defendant 2 stating that $1.2 million is but a trifle to him. In Exhibit 13, we have another undertaking, a statement by defendant 2 that, of course, he's going to perform the contract.
It was Exhibit 14 that I had in mind when I mentioned to you the question of the first defendant being helpful about the second defendant's assets.
Well, with regards to Exhibit 14, of course, defendant 1 is retained as an advisor, a professional advisor, who is licensed as a tax attorney, as an accountant, by the claimant. So as far as what is being stated here, I mean, he is making general comments that have no specificity, are not providing anything more than, I would say, comfort. Of course, if the defendant 1 was saying, oh, there is actually this property deed I've located. Here's a copy of it. That, I think, is a different level of cooperation than a statement that is made that, oh, yeah, he has these. Maybe it's not in his name. So for that reason, Exhibit 14, as it is translated and written here, does not represent conduct by defendant one that is helpful to the claimant. That is our position.
Do you know, or do you suspect what the two assets are that are being referred to?
We do not have a clear.
The difficulty is this, isn't it, Mr. Gunson, that everything that is said before the contract, and indeed during the course of the contract, is all terribly general. You know, I'm an enormously wealthy man. A million here and there is absolutely nothing to me at all. But there's no specificity at all about any actual assets, as far as I can see. Again, I may have missed it, but I couldn't see particular things that were identified as being assets that he said he held as such, that he now is denying holding in his witness evidence as furnished to the court on his application.
Well, then I would refer back to Exhibit 6 and 7, which is the text of the contract that says the investee is not investing in, he is currently running various businesses in the UAE.
Yeah.
This is contractual, part of the contract.
Yeah, yeah. So if you had to put in a list the assets which he's failed to disclose, of which you have knowledge, what would it amount to?
I would think it is most likely real estate and shareholdings in businesses in the UAE.
Yeah. Or shareholdings elsewhere. He's mentioned, what, 7 or 8 companies in his witness statement, all of which he says are worth virtually nothing, and his shareholders therefore are worth even less. But you hope that there's some real estate and shareholdings in the Emirates against which you may be able to enforce, including those he may have transferred to his wife or others.
That is a possibility, and I think it's also suitable at this time to mention the settlement offer that was communicated to us by opposing counsel that was not without prejudice. And for that reason, I believe can be disclosed to the court.
Yeah, is that the one where he talks 25% of the figure?
No, Your Honor, this is a recent development that occurred after the order was given, but before the 28-day deadline had passed. And it is the background by which the 13th June order application was made by defendant 2.
So have I got evidence of that in the bundle?
But we have not submitted evidence of that. As I said, it is, I would first confirm with the court that this communication to us by counsel that was made in writing, but not without prejudice. I'm of the view that this can be provided to the court as additional evidence.
Well, Mr. Gunson, you need to decide whether it is or is not a without prejudice offer. If it's without prejudice, you can't refer to it. If you're convinced that it's an open offer, then that's you can tell me all about it. The difficulty about without prejudice is, as you know, that it doesn't always depend upon whether or not you've attached the label to it.
Your Honor, thank you. I think I would mention that I think it's suitable then to disclose that defendant whose counsel has given an offer to satisfy the judgment of around $800,000, making claims that, oh, well, we can borrow money from family and we can, but that's the maximum we can pay. Now, that is completely in contradiction with the statement that's made in the 13th and 18th of June applications. Now, if it would indeed be loans from family members to partially satisfy the judgment, then that may not impact the truthfulness of the 13th and 18th of June applications. But given that that communication was given to us first by phone and then in writing, pursuant to which we actually drafted a settlement agreement, which before we could proceed with further and seeking to negotiate with the defendant whose counsel, we received this 13th of June order or application, which of course is something that we know contains multiple misrepresentations and falsehoods.
And if I remember rightly, the total figure that he comes up with, estimating values of his shareholdings and so on, is about 188,000, isn't it?
Correct.
Yeah. Yes.
And yet, there is an offer that we've received in writing to settle the entire judgment for $800,000. So this gets back to the behavior of defendant 2, which is also demonstrated in other exhibits that have been attached to our application, that the defendant 2 is seeking to do everything he can to not honor this judgment or to have it result in the minimum amount of damage to him, which to a certain extent we can all sympathize with. That's a reasonable position for anybody to hold. But he's not seeking to do it through fair disclosures. He's seeking to do it through false disclosures.
Yes. And just tell me this then. The application that he's made, what is happening to that? He's made an application, as I understand it. I'm sorry, he's filed witness statements. Has he actually issued a formal application?
Well, if to confirm the timeline, there was first the application made on the 13th of June, which was followed immediately by our communication to defendant 2's counsel that this was not complete. We then have the subsequent filing of the 18th of June. Our response to this has been submitted to the court and is quite brief, simply stating that whatever this application is, it appears to have no basis in law, and for that reason should be rejected. So whether or not the court would consider that.
But has there actually been a formal application by the defendant? I couldn't see a formal application notice. There was this communication to the court with a witness statement saying, this is what we want. But, you know, if someone's going to make an application to court, they have to file an application and pay an application fee and so on and so forth. And I've assumed he hasn't done that.
The court fee was paid of $300. But I think that our response provided on the 25th of June states a position very similar to what Your Honor is stating now. Although it's not in our position to say that this application is not even valid. We are simply stating that it has no basis in law and it should not be valid.
I understand all of that, Mr. Gunson. The only question is whether there has been an application which I'm going to have to deal with at some point. It doesn't affect us today because you come as a matter of urgency in any event, notwithstanding that application. In the context of where there's a judgment against him, you know, a person who comes along to the court and says, I can only pay by installments and so on and so forth, you know, sometimes, of course, parties will then say, all right, well, I'm happy to accept it by installments as the best you can do. Your position is that you don't think he's being honest at all, and you want an injunction to see what else you can find and make him disclose what he's really got. So I understand all of that. I was just trying to understand quite what the technical position was on his applications and whether at some point or other I'm going to have to deal with those as well.
Well, Your Honor, I thank you for the question. And if I was to give an answer, I think that there is no valid application.
Okay. All right. What else do you think you need to show me? Good arguable case, there's no issue because you've got a judgment already, and I've made findings before about the weakness of the defence, and if there's no money put into court, judgment is there and you can execute. Risk of dissipation, I'm entirely happy with. It seems to me that on the face of it, there's evidence certainly of dishonesty beforehand, and then a history of prevarication and procrastination in relation to payment, and of course, above all, simply the fact that he's failed to observe the contractual terms of repayment within a year, and is saying different things at different times about the assets he's got. So I'm entirely happy about the risk of dissipation as well. So what else is that?
I think your Honor has mentioned what I think are often seen as prongs 1 and 3 of freezing relief. So I think we'd now refer then to what are points 2 and 4. 1 being the good arguable case, which has been covered. Point 2 would be for assets available for enforcement. Well, the application made by the defendant makes multiple statements in this regard. Luxury vehicles, watches, cash, real estate, even if it is mortgaged to a bank, interest in various companies, one being his management consultancy, for which the website has now been taken down. There's one more important point, which is that we have not at any time received, nor has the court received in the applications of 13th of June and 18th of June, any information on where the investment proceeds went.
Yes.
And the claimant, as a reasonable person, if there had been full and fair disclosure that, look, we invested into company X, and company X has since gone into liquidation. For this reason, I regret to say that we're not in a position to honor the contract that's in its terms. That is not what has been done at all. Very likely, with that, to purely speculate, it would not be a surprise if this amount of money was just used for defendant two's lifestyle.
Or one of his many failing companies.
Your Honor, correct. We have.
Anyway,
so this I think is covered.
Plenty of evidence of some assets, as you say.
And given the defendant two's behavior, we can then also wonder what additional assets might be revealed if the court was to issue a disclosure order that then required the defendant to disclose that information.
Yes.
So that is the second prong of the freezing relief. Number 3 being risk of dissipation, which we have just discussed previously and you've accepted. And then finally would be point 4, which is just inconvenient.
Just inconvenient, yeah, sure.
And I think here also that given what has been set out.
It goes with the other points in reality in this case, doesn't it?
That is our view, Your Honor.
Just bear with me a moment. Thank you very much. Thank you. I'm sorry, I'm conducting this from a small room at an arbitration centre because I've got an arbitration beginning in fairly shortly. So a chap just came in with bottles of water. Right. Okay. Well, that covers the ground. I mean, I'm satisfied this is an appropriate case, and both for a freezing order and for an asset disclosure order. So the question now is as to the terms of it. What I asked the registry to do, and I understand they've done, is to send to you what is shortly to become the new form of model order in the courts. It's based upon the current model form in the UK, which a judge in the DIFC has adapted for the DIFC. So I think what you're telling me is that you've provided a new draft to the registry, which follows that form. Is that right?
We did receive from the registry this morning a draft order. We have revised that order in track changes and returned it by email to the court.
Let me just see. I think I've got that, but I haven't had the chance to look at it yet. Yeah, I've got it now. So are there any significant differences that you need to draw to my attention?
I don't believe so, but I'm happy to go through the changes that are there.
Please do that.
So I think for the cover page and the penal notice, the changes are self-explanatory. Then also in the conduct of the order, the return date is blank in point 4, depending on the decision of the court.
I have, but before you go there, the penal notice point has been the subject of a considerable amount of debate because the old form, which said you may be imprisoned, fined, or have your assets seized, is still technically correct because, of course, you may be imprisoned following reference to the Attorney General. And I always think that that has a salutary effect. So personally, and not all judges agree with this, but if you wanted to include a slightly stronger version than the model, I would be happy with that. So, for example, if you, Mr. Rashid, disobey this order, you may be held to be in contempt of court and may be referred to the Attorney General of Dubai and imprisoned or fined or have your assets seized. Now, in practice, imprisonment may or may not follow. It's a matter for the Attorney General as to what he does. And fining is often thought to be the most effective way forward. But if you wanted to strengthen that, I don't have an objection to it. So it's a matter for you as to how you wish it to be dealt with, as long as you understand fully that any question of imprisonment is a matter for the Attorney General and what he decides to do thereafter.
Your Honor, we will submit a track changes revised order within 30 minutes of the conclusion of this hearing.
Okay, well, you decide which form you want, as long as it complies with one or the other. I'm happy. Thank you.
Thank you, Your Honor. So I'll return then to the proprietary.
Is this really a proprietary asset preservation injunction as well as a freezing order? I suppose it is. You say that because you're trying to trace the proceeds of what you've put in his hands, which you say you're entitled to as a proprietary remedy as well as simply a damages remedy, or not?
Well, I think that the court's model form does also mentions freezing injunction following to that, but I think that
yes, it does.
Yeah, proprietary injunction I think is suitable in the sense that we do not. I think it's fair to say that the claimant's biggest concern would be that proprietary assets would be transferred to another member, perhaps of his family. So not disposing them to receive cash that would then satisfy the judgment, but to transfer them away from his direct ownership, but which are still within his control.
Yeah, but there's a separate point there, Mr. Gubson. A freezing injunction simply has the effect of freezing all assets that are in his possession. A proprietary injunction is based on the fact that you say that your client is entitled to specific assets. The difference between a proprietary injunction and a freezing injunction is one is simply freezing, and that includes can include matters that he's transferred elsewhere. But are you actually saying that these assets are your client's assets, or is it simply a damages claim you're pursuing?
Our client has no interest in any actual assets other than cash, subject to the comment that if the claimant's investment amounts were used to purchase these assets, then at least we would say morally he would be entitled to that, although it's not, the claimant has no interest in anything other than monetary satisfaction of the judgment. But we are not a secured creditor over any of these assets. So
that's what I thought. I think what the registry has done is to send you a copy of the proprietary and freezing injunction model form, not the pure freezing form, so that there's some proprietary stuff in there that's not actually appropriate. So that what I'll do is I'll get the get the registry to send you the other form, which is slightly different, but basically takes out the proprietary entitlement point. There's a difference between such the forms of injunction where you actually claim the property in question and where you're simply claiming damages on the basis of a breach. It's not very significant, but it does affect, obviously, paragraph 1.
Your Honor, thank you for the education. Certainly, it's subject with the caveat that what I said before about the claimant's investment being used to purchase certain assets. Subject to that, of course, I would say theoretical comment. This is not a proprietary injunction subject matter claim. It is one for freezing.
Exactly.
And disclosure.
Yeah. All right. So paragraph 1 will need the proprietary bit taken out, but leaving that aside, let's move on. What else do you need? Yes, there you are. You've got, if you could look at paragraph 6, you've got a proprietary injunction as opposed to a freezing injunction. And if you go to paragraph 8, you've got the freezing injunction. So what you need is paragraph 8, but not paragraph 6.
So I understand that we should amend paragraph 1 and also remove paragraph 6 and 7, and the changes in paragraph 7 are reflected elsewhere in the draft order.
Yeah, exactly so. Exactly so. But you're freezing only assets in Dubai. You're not looking for worldwide freezing. I should have thought you were.
So, Your Honor, we would request a worldwide freezing order.
Yes. Well, Mr. Gunson, you're going to have to redraft this in conjunction with the assistance of the court on getting the right form, which is a worldwide freezing order, which contains provisions that he can use assets in excess of the figures that are frozen, as long as he reveals where they are and so on and so forth. And then you've got the asset disclosure point. So I'm afraid what we've got here is not the appropriate form of injunction as such. I think the easiest thing is for me to say that I'm happy to grant you a worldwide injunction, freezing injunction in the ordinary form, the model form, with consequential amendments to fit your case. And that includes paragraph 9 and then paragraph 10. What are you going to do about paragraph 11 on living expenses and so on?
Well, on this, Your Honor, we request perhaps the court's guidance in the sense that we would like this judgment to be satisfied as soon as possible and the freezing order lifted. But I think that the court would probably instruct that, or possibly instruct that there is some limitation in this regard. But we await.
Well, the normal problem is to assess what is a reasonable amount, not knowing what assets he's got, not knowing what assets his wife has, not knowing what his standards of living is at all events. From what I've heard, he has a fairly exotic lifestyle that would appear not to be justified. But the way this works, Mr. Gunston, is that you put an amount in that you think is an appropriate amount as to what you would expect a person in his position to have to pay by way of ordinary living expenses on a weekly basis. If he thinks that's not enough, he can always come back to the court and ask for more and say, look, I've got these commitments and so on and so forth, I have to live and all the rest of it. At present, you've provided for a return date, and I think that's, in these circumstances, probably sensible, for something like 2 weeks' time or something of that kind. And he's got the opportunity, or will have the opportunity, when we look at the provisions at the end, to come back on 48 hours notice if there's some urgent reason to come back before the return date, because he can't survive on without further relief from the court.
So, Your Honor, yeah, thank you for the instructions. We will consider
and
this.
You can talk to the registry about that if that's going to be of any help, to find out what's is ordinarily done and what sort of figures are ordinarily put in. But you will have a better idea than I about his likely weekly expenditure in Dubai, if that's where he's currently living.
Your Honor, thank you very much. We will receive the worldwide injunction draft from the court, and promptly, I undertook previously 30 minutes from the conclusion of the hearing. I'll now ask for that undertaking to be amended, but I would expect
sure.
within an hour or two, we would provide a revision to the court.
It's okay. And I'm just looking at the disclosure provisions. Where are the disclosure provisions?
There are, after the exceptions to the order, there is a provision of information.
Yeah, paragraph.
Revised paragraph 13.
Yeah. Yeah, here we are. Yeah, you see, I mean, what you've got in 13.2, you've just got assets in Dubai, whereas what you want is worldwide.
Although 13.1 does address worldwide assets. Oh, that's proprietary assets. So
yeah, well, that's the point. You see, you've got to get this right and consistent. What you want, and what is ordinarily done, is to acquire within usually 48 hours of service of the order information about assets that exceed $10,000, and then within a period of, say, 7 days, an affidavit which confirms and gives full details of all such assets. So, you're giving a person the opportunity to tell you straight away all those things that he can, and then to give a fuller and sworn version within a week or so thereafter. So that would be the ordinary form that I would think was appropriate. Oh yeah, well, you've got that in 14. Yeah, there you are. Within how many days? You put in 14. You can't see how many, but it's sort of 2 days for information by way of letter, so to speak, and either 7 or 14 days for an affidavit that sets it all out in detail, with copies of documents and all the rest of it. Okay, and as I say, if you get the form of order off the court, that will be helpful.
But Your Honor, we will review the separate templates and provide that to the court as soon as possible.
Yes. Now I'm going to be in arbitration from in about an hour's time, but I do have breaks during the day, so I should be able to look at it at some stage during one of those breaks and give approval to it. But as I say, you need to make sure you've got the right form from the court, and the person at the registry may or may not know exactly what it is that you want. But what you're looking for is the pure freezing order and asset disclosure order for worldwide assets. Okay.
Your Honor, thank you very much.
Hold on, let me just get rid of this. Right. Sorry, I've been unable to look you in the eye while I was looking at all these documents, but there we are. Are you confident about where you're going on all of that. You'll need an undertaking in damages, but you won't need to fortify that in any way because you've already got a judgment. You don't need an exception in relation to ordinary business expenditure because this is a personal judgment that you've got. And so the only exception really that is relevant is simply what he needs to live on in the meantime. As for a date for the return date, the sensible thing would be to fix it for a date that I can do. So let me just look at the diary. What are you going to put in for the affidavit? Do you think? I mean, he's already had a go at this, in a sense. He knows what he's got to set out because he's already set it out in part, however fully inaccurately, dishonestly, or whatever, in his applications. So that if you had 48 hours for him to disclose by letter all his assets, and then within, shall we say, 10 days, an affidavit that gives all the details of them and provides documents in relation to them. If we then had a return date about 14 days from today, that would seem to me to be fairly appropriate. We are today the 2nd. I could do the 16th of July if that works. That's 14 days from today.
Your Honor, we are available.
Right. Well, return date will be the 16th of July then.
So, Your Honor, I think I'm confident we understand your instructions on the revisions to the draft order. So on the conclusion of this hearing, we will speak to the registry immediately to confirm we have the suitable template. We will then revise that immediately. And as soon as possible, which is certainly not before your arbitration proceedings commence in an hour, but shortly thereafter, it will be with the court, and we look forward to review and thank you in advance for doing so.
Yeah, I'm just trying to think how this will work out. In practice, if I'm only going to be looking at it at a lunch break, 1 o'clock, that's going to be 4 o'clock Dubai time. Well, you might just get it back tonight from the court if you're lucky, but it may, in practice, not come through till tomorrow.
If the order is issued tomorrow, should the return date be amended from the 16th of June?
No, that'll be all right. No, that should be all right, because if we're giving 10 days for his affidavit, you will then have time to absorb it, and whatever you need to do on the return date, then we can then consider. I'll talk to the registry in a moment. Unless there's anything else you think you need for current purposes, I shall invite you to sign off, and I will then talk to the associates of the court.
Your Honor, there's one final point, which is the defection in my affidavit that you referenced at the start of the proceedings.
Yes.
So
yes, well,
we'll look at this and provide a revision.
Again, if you can, it's a 1-paragraph job, so that you should be able to provide that at the same time as you provide the draft order, I would have thought. And in reality, Mr. Gunson, because I'm unlikely to look at this before 1 o'clock my time, as long as you get it to the registry within the course of the next 3 hours or so, that should be okay.
Your Honor, we will complete this within 3 hours.
Very good. All right. Anything else from you, Mr. Gunson? Otherwise, you're happy?
Your Honor, thank you for your time. We appreciate your professional review.
All right, thank you very much. If you and
Yes.
anybody else in your team with you would like to sign out, I will then have a word with the associates. Thank you.
Yeah, so Connor Bucket is also on this call as a separate guest. We'll both log off now. Your Honor, thank
Thank
you
you very much. Thank you.